Morning, everybody. Honorable Mr. Justice Vikramnath, Honorable Mr. Justice Masi, Honorable Mr. Justice Upadhyay.
Pankaj Mittal.
Sir?
Justice Pankaj Mittal.
Yes, correct. I wouldn't miss that, sir. Honorable Mr. Justice Pankaj Mittal, Mr. Thiru, my dear friends, Bar Sanjay, all seniors, delegates, friends. I'm conscious that we are running horribly behind schedule, and therefore I'll compress what I want to say possibly in about 3 or 4 minutes. I wish this was actually a conversation just on artificial intelligence, because that makes it very exciting in terms of what's happening globally, how machine learning actually is transforming the legal profession and justice delivery itself. But we are really speaking about global perspective on challenges to the judiciary from artificial intelligence, and therefore I put some thoughts together, which is a 10-minute break. I'll be very crisp in terms of what I think where we are going. All times, every conference that I have been to, from the time I began my career to possibly 3 decades plus now, that we've been speaking of docket explosion. And docket explosion, docket management, what do we do? Lots of people have got PhDs in docket management in this country, etc. But our docket problem of 50 million cases still continue. And the trend over the last 4 years has been that when it comes to artificial intelligence, everybody speaks about artificial intelligence, the perils of AI, the perils of integrating AI into the judicial delivery system, but nobody speaks about the positives of AI in terms of justice delivery and not justice inter partes itself, because justice inter partes is a much smaller cohort where you can actually talk about problems of AI, etc. But when it comes to justice delivery as a broader platform, I, being a technology lawyer, I don't actually see the negative, and there are huge amounts of positive. I've always maintained that we are in the nascent stages of AI, 3 phases. The present decade is actually the transformative decade till 2035. 2035 to 2045 is actually when systems will fall into place. 2045 plus, and some say it may be 2060 plus, is actually the future of AI in terms of AI transforming itself into the justice delivery system to actually deliver that pinpointed justice. Now, will that happen or not? Nobody can say. But let me go back to 1942, and that's something which has always stood in my head. The whole issue of artificial intelligence as we know it today really did not begin in terms of artificial intelligence. It began really as basic rules of robotics, because we were in an analog world. The whole systems were analog. They were not digital at all. And therefore, in an analog world, from a perspective of aiding and assisting human beings, robotics came to play. And sirs and madams, a lot of us may not remember this, but the whole rules of robotics also started with a science fiction set of rules and not really the physical or dynamics or physics set of rules. The science fiction rules in 1942 in a science fiction magazine in the US started as 3 rules of robotics. First, a robot should not harm a human being or assist anybody in harming a human being. Second, the second rule, that a robot should always assist a human being in doing a task subject to the first rule. And third, a robot must always protect itself and propagate itself subject to the first 2 rules. Now, the problem is with the third rule when it comes to artificial intelligence, because you looked at from a physical domain and you move it into a digital domain where data sets come into play, computing technology comes into play, a combination of nanotechnology and emergence of large format computing technology means that this phone is more powerful than an IBM mainframe which existed for the longest of time. So consequently, and when you have data sets given to it, what happens in that computation and how AI really impacts is the story today. That third rule to say that a robot will propagate itself subject to, of course, the first 2 rules of not harming a human being and assisting a human being, today has actually become the mainframe for judicial dispensation. First, in our country, I believe that artificial intelligence as a process can actually aid and augment a judge in ensuring that our docket explosion is arrested and justice delivery begins. It is impossible for us to have the logic of saying we will increase our number of judges and automatically docket explosion will be controlled and we will deliver justice. Pendency will vanish, because it is impossible for human beings to do it given the numbers that we have. Every second person can't become a judge. How do we do it? We do it by actually augmenting a judge to facilitate the judge to do it, and the simple example is this. If a matter of a particular issue comes up before, let us say, a judge of the Honorable Supreme Court in a division bench, why is that AI, in terms of docket management, does not list all matters in which that question in some form or the other relevant? Because every third day we turn up and say, this is a covered matter, please dispose it of. To see whether it is covered or not covered, the judge then expends time and effort. The docket management is that it is get listed, it goes to the registry, the list becomes long because you are looking at whether a matter is covered or not. Some other matter which is not covered is not being heard. We have 50 million cases in this country, plus minus. I'll give you a statistics. Artificial intelligence is enabling Uber today as we speak to pair 45 million drivers and 45 million cars every day, because 45 million trips are taken every day in the world. And Uber does it seamlessly. We have not really had a case where every third person says the Uber car which has come to me is not matched, somebody's car is sent to me. If an Uber can do it with AI-driven algorithms, why is that the judicial system can't do it? For two reasons. Constitutionally, our judicial system is public access. It should be actually accessible to the public. Second, it is not something that can be delegated to the machine because a human mind and human element has to come in. Third and most important, judicial system must be accountable in our constitution. The problem with artificial intelligence today is accountability. And I again bring three reasons on accountability. Number one, accountability is not about the efficacy of the algorithm. Accountability is about the transparency of the algorithm that is available for a public audit at any point in time. All judicial systems in this country, sir, is amenable to public audit. Now, the problem with AI is that when you have a platform driven by an algorithm, and that algorithm is crafted, let us say, by a private interest, which is a private entity or a private corporation driving the algorithm, that unfortunately cannot be brought to bear in justice dispensation. For two reasons. Why? Because it is privately held. Second, most privately held technologies in the world today are black boxes. They are not amenable to a public audit. They are not amenable to public scrutiny. And if that algorithm actually arrives at a conclusion which is wrong, and I am appealing that conclusion, I am unable to critique that algorithm because the access to that algorithm for public audit is not available to me. Even private audit is not available to me. So that black box theory really prevents the import of artificial intelligence into the justice dispensation methodology. What's the answer? The answer really, and I'm being very, very crisp on this given the time, the answer really is something that we in India have actually emerged and been successful. Traditionally, China uses AI when it comes to justice delivery. Brazil has been the leader. We really don't look at Brazil as a leader when it comes to AI and governance in terms of public domain, but Brazil has been the leader in terms of docketing cases of a particular mandate on penalties, etc., for smaller offenses. Now, in a case, and which happened in 2016, and that's a decade earlier, where there was a penalty imposed and the party wanted to challenge that penalty, one of the questions that the party raised is that the docketization of his case along with another matrix of larger cases was wrong. And for which he said, I have to get the audit rights of that algorithm to see whether it is done correctly or wrong. And that raised the issue of where is accountability if you cannot audit. Now, how do we achieve that was the question. The achieving is this. Let me give an example, and we have, of course, the Niti Aayog here. What we have done in our fintech processes in this country, and that is there for us to accept, is not what we are doing in the judicial processes. And in particular, let me appeal to Honorable Mr. Justice Vikramnath. Sir, when you are going to helm the affairs, please consider this. We have about 15 billion transactions on UPI infrastructure every day in this country. We have about, I think, multiple trillions of rupees worth of transaction happening on UPI every day in this country. Now, why is that UPI architecture actually amenable from a perspective of public acceptability and nobody is raising questions? Why? Because that UPI, it's either Google Pay, it is Phone Pay, it is Amazon Pay, they are all private. But nobody raises those questions. That is because a Google Pay, an Amazon Pay, Phone Pay, or tomorrow if I really put up a Povayya Pay, are only skins, and those skins are wrapped on a body which is actually a public domain infrastructure and API, which is the National Payments Corporation of India architecture on UPI payments in this country. And countries even like Singapore are wanting to borrow that public infrastructure because it is accountable, it is auditable, the public key initiative is always available in the application program interface, and therefore there is no problem with that structure. Now, unfortunately, when it comes to the judiciary, we believe by virtue of digitization and AI, we have actually gone online and therefore we have achieved something. Respectfully, sir, to say that we have gone digital in the sense that our cause lists come digitally, our briefs are today digital in our iPads, and we can do our hearings from any part of the country digitally or even sitting abroad digitally, is really to say that I am replacing a typewriter with a computer for the computer to do the typewriter's job. It is just going to print out and give it to you. You don't bring computing to substitute a typewriter. You bring computing to bring efficiencies in the system. Now, if the judiciary really should manage its docket, and I mean that from the bottom of my heart, you really need to develop a public key infrastructure which is the heart and soul of integrating artificial intelligence into the docket management system so that it can augment a judge to deliver justice and not substitute a judge. Because the substitution of the judge are fears today, and I'll end with that scenario. The whole scenario today in any AI conference world over is, oh my God, the replication is, you please see that judgment. There were 4 cases which never existed, which AI brought. You please see this judgment. The judge used a particular logic, which was actually an AI logic, which is wrong. Those are actually critiques of the system. Hallucinations is inherent in mankind. And it is mankind which develops AI algorithms. Therefore, hallucinations in AI algorithms will always exist. A wrong decision coming into a judgment or a non-existent decision of X and Y being used in a judgment are hallucinations of artificial intelligence. You don't kill the messenger for the message. What do? You therefore build an algorithm which is institutional, and the only institution which can do that in this country is the Supreme Court of India, given the separation of powers, given the constitutional mandate of justice delivery, etc. And that public infrastructure which is built by the Supreme Court, which does not cost too much money. Please manage the UPI infrastructure in this country, it didn't cost billions of dollars. That infrastructure is then given to all courts in the country in terms of how it is managed. I'll end the last. You will never succeed in artificial intelligence unless you have interoperability, and interoperability is the key. You can't have a scenario where one court runs on a particular platform, another court runs on another platform. The dockets of one court to another court is not interoperable. The dockets on the judge's bench, which is digital, is not interoperable with mine because I'm using a different platform, they're using a different platform in terms of digital integration. This common infrastructure which remains, and then each high court, each district court becomes the skin on it. So it could be a Google Pay, Phone Pay, etc. So it could be the High Court of Karnataka, High Court of Delhi, it could be the district court in Manjeri in Kerala for all we know. But the public infrastructure being developed by the Supreme Court is the key, and therefore if you're looking at digitization, the key is possibly to spend the next 18 months to develop that public infrastructure and then hand it over to the courts of the country. 50 million cases will be managed in no time. Respectfully, with that I'll end. Thank you very much.